principles of reparations and how they're organised, and have a discussion about that before we focus in on the specific conditions in Guatemala. And we've got a little video again. If you've got time, we've got a short video of the Shishoy Dam and the reparations surrounding that in Guatemala as well. So this week we're going to cover those 5 bulleted points to begin with, as a sort of a general outline of reparations and a discussion on that. So what's the legal basis of reparations? What challenges might there be of creating reparations? Are there any real drawbacks or advantages of individual reparations versus collective reparations? We're going to also contrast and compare reparations and development, often confused or masquerading one as the other.
Please.
And we're going to look at Pablo Kalmanovich's article, Corrective versus Social Justice. That's all hopefully before the break. A little break, and then afterwards we'll have the debate on Guatemala and the video at the end of it if we get time. So quite a lot to get through, as usual. So we'll kick off with the basis for reparations. So let's get ourselves warmed up by asking ourselves the question, what is the origin of reparations? What's the legal or the international legal origin of reparations? Who can tell me based on the reading? The obligation to provide reparations.
It was in the, I can't say it properly, something factory case, where they said that it was applicable in international law that the breach of an engagement involves an obligation to make a reparation in an adequate form. And then from that, there's a lot of international instruments that discuss the...
Keep going.
Yeah, that word, I can't say it.
Yeah.
We discuss reparations, so in the OHCHR reading, they list quite a few. So there's like the Article 8 of the Universal Declaration of Human Rights, the International Covenant of Civil and Political Rights, that's Article 2 of that, Article 6 of the International Convention of the Elimination of All Forms of Racial Discrimination, and it goes on for quite a lot, but it's on page 5 and 6. But yeah, it's basically that case that describes reparations.
Great, thank you, Jessica. Do we have any Polish speakers in the room? So how would I pronounce the first word? Chorzów?
Chorzów.
Chorzów, okay, that's the right thing. Chorzów, so the Chorzów factory, I think it's a Polish name. So that was the case that Jessica was referring to, but it relates to the international law obligation on states, who, as you will be aware, are traditionally the bearers of obligations. The obligation on states to provide remedies, to provide effective remedies for violations of human rights. Now, in parallel with this international law obligation, there are, as Jessica has outlined, numerous international human rights law treaties. We could mention the Universal Declaration on Human Rights, Article 8. Everyone has a right to effective remedy by competent national tribunals for acts violating fundamental rights granted by the Constitution or by law. So we could go also to Article 2 of the International Covenant on Civil and Political Rights, a similar sort of formulation as we've just read out on the Universal Declaration on Human Rights. We could look at the International Covenant on the Elimination of All Forms of Racial Discrimination, similarly the Convention Against Torture, and the Convention on the Rights of the Child. So all of those articles that we've got on the screen relate to the obligations of the contracting parties, who obviously are states, the obligations of states to provide effective remedies for individuals whose rights have been violated, according to specific international human rights treaties that we've listed there. So those are the, if you like, the substantive legal provisions. Can anyone tell me about the two different dimensions? So we have the first dimension, which is the substantive dimension, the duty to provide redress. What comes after that?
Practical application.
Yeah, great, thanks, Pippa. So there has to be not just a paper-based obligation, there has to be also a procedural dimension. Okay? So how will rights holders in practice access the right to redress? So each of these conventions and all of the specific national pieces of legislation are required to clearly delineate what it is that those whose rights have been violated have to do to procedurally access their rights. Okay. So how will they access the rights or satisfaction for violation of those rights in practice? There has to be something. Well, how would a rights holder access their remedy? What would be the normal route? What could be the route? Anyone? So if you've had your rights violated, who would you complain to? Court. Yeah. Whether it's the national court dealing with general claims against the state, whether it's a specific tribunal set up to investigate particular violations, or whether it's even an international tribunal, whether it's the Human Rights Council or any of the commissions set up or courts set up. Maybe you want to say something?
Yeah. I think it goes in the order of your national law stands before or supersedes any international law that exists. By that order, it would first be approaching a national court, the Human Rights Commissions, followed by intergovernmental organizations like European Court of Human Rights or Inter-American Court of Human Rights, and then moving on to maybe more international sort of through petitions, through nations calling for certain committees to be set up through the General Assembly or the Human Rights Council.
And why is that, do you think? Why should there be that hierarchy? So the first port of call will be your domestic authorities and then beyond?
Because I think that stems from states being subjects of international law, and if they haven't ratified any of these treaties, but still within their domestic law, because the UDHR is a jus cogens norm, they have the obligation to provide some kind of relief to the people, and it's the obligation of the state, just by social contract, to be able to provide these to the people. So that exists, that hierarchy of first. The mechanism is the state's responsibility to protect their state, and when that doesn't come, you're looking at a shift from just the national obligation to bringing in the certain more.
Yeah, good. Amanda?
Oh yeah, I agree with that, but I think it has to be with the principle of exhaustion. Like you have to go to the state remedies first, and after that, if it doesn't work, if they don't provide the right restoration to the right that was violated, then you can go to an international court. So it's like guaranteed sovereignty of the state, and after that, if it's not capable to actually address this violation, then go to international courts.
So, absolutely right, thank you, Fernanda, for that. You have to exhaust your domestic remedies first. We all know about the European Court on Human Rights. Will not entertain any claim by an individual unless they can demonstrate they have exhausted all of their obligations, all of their avenues for redress at the domestic level. And we'll see an example of that in Guatemala and the Inter-American Court of Human Rights that dealt with some of the claims in the Guatemala reparations issues. So, yes, the state bears the primary obligation vis-à-vis its citizens to remedy any of the violations that it has perpetrated. And as Viva and Fernando have said, if those cannot be remedied at the state level, all of those options have been exhausted by the complainant, and it will be elevated, or the claimant can then move on to the international level. Well, let's just talk about the international, the success or otherwise of claimants bringing cases before international bodies. Don't have any comments or thoughts on that. So if your national jurisdiction has not satisfied you or has rejected all your claims. Philip?
I think there are certain cases which are beyond national jurisdiction. Like, for example, when you look at slavery in America or like European colonization of many African and Asian nations, you can't seek to go to your national system to redress something that happened before a national system existed. But then again, there is this question of how far behind do you look in reparations and I think in 2009, the US government passed a law apologizing for all the slavery that had been committed against African Americans. You know.
What do you think of that?
Sometimes it's not possible to approach, and then I think the entire system kind of falls down because there isn't one central body that you can approach, and it's always a matter of collective claims as opposed to single individuals. And usually it goes overlooked or is not considered in the fray because relatively it's a smaller community as opposed to an entire community being addressed.
What does everyone else think? How far back should we go? Thanks for coming. So how far back should we go, do you think? So there's an example of the government of the United States giving an apology for what happened some hundreds or so years ago, 150 years or so ago. Is that fair, right? What do you think, right?
Well, hypothetically speaking, since reparations also seek to redress sort of gross violations of human rights and of humanitarian law, then if you talk about how far we can go, you open up Pandora's box of the whole sort of black hole of colonialism as well. And that just goes back into the 19th century as well. So I think for me, perhaps, it's while there is justifiable reason to go back into certain gross violations of human rights that have occurred over time, e.g. through colonial times, it would be, in a large sense, impractical to do that. So perhaps what could be of use is the non-retroactivity of certain treaties and disapplying them.
Okay. Non-retroactivity. What do you say?
I kind of don't agree with Brian's point because personally I believe like the starting point to look at reparations is an apology or an admittance of guilt or the fact that something has been done. For example, the fact that nobody in a British curriculum is taught about all the atrocities that were committed by the colonial powers in colonized countries, and they're riding on this high horse of talking about victories in terms of victories. I think the first step, if you go as back as it takes to acknowledge the guilt, because it's not just monetary loss, it's not just loss of lives, but an entire societal structure that's been changed. And there's been creation of a lot more societal divisions because of these colonial impacts on developing nations, and these nations stand as developing as opposed to developed nations because of the impact of this. So I think the beginning is like taking a moral aspect of it and saying reparations is not just for physical damages or in terms of monetary loss, but just an admittance of guilt as a starting point.
Okay, so we've got the two sides of the argument here. On the one side, we've got the sort of moral imperative for apologising for something that was wrong, that has had an impact on the way society has developed. And then on the other, we have the argument that this potentially could open Pandora's box. Legal obligations, financial obligations, not just moral or symbolic, but hard cash implications might happen to those apologies. We'll leave it there hanging in midair as a debate, but it's for you to determine where you think, if you're going to write a dissertation on reparations, or if you're going to write one of the coursework questions on reparations, where you fall on this. Okay, are there any other forms of international law under which reparations might become payable? Right?
Well, the International Criminal Court
Yeah.
is very sort of synonymous for offering reparations and quite significantly in the Thomas Lubanga case, where it specifically ordered for reparations for some of the victims
Yes.
that have been involved. And I think, doesn't the ICC also have a full reparations and compensation stage in the whole trial process, which is sort of looking into providing reparations for some of the victims or the people brought, or some of the accused?
Exactly what we're looking at. Do you know where they're up to in their reparations program for the Lubanga case?
Well, it just, I'm not sure at what stage specifically, but as of October 21st, the trial chamber had approved and gave the trust fund for victims to the go-ahead to implement the symbolic collective reparations in relation to that case.
Exactly. So the International Criminal Court in The Hague created a so-called trust fund for victims, victims at the ICC, which was created in 2004. The Thomas Lubanga case, the first case that was concluded at the ICC, concluded in December 2014. Obviously had thousands of victims relating to the child soldiers that Charles Taylor was convicted of conscripting, and the preliminary implementation of the reparations plan for victims was underway from February 2015, or at least the plan was drawn up in 2015. 2 years later on, so March 2017, none of them have been fully implemented. So this is a very, very slow process. Just to read a little from the aims of the Lubanga reparations, the International Criminal Court's Trust Fund for Victims talks about the importance of reparations in reconciliation between victims and their families, and the reintegration of child soldiers into the community. So those are the twin aims of the reparations, not just to give handouts to people that suffered, the victims who suffered, but this tying reparations to other transitional justice aims, tying the reparations to reconciliation and tying reparations to reintegration. You might have come across the term DDR, demobilisation, disarmament and reintegration. That's a programme that transitional justice practitioners and those states who attempt transitional justice mechanisms will look at, particularly where there's been a violent conflict in which there have been soldiers who could potentially be considered to be perpetrators and victims themselves. And this happens where particularly there have been allegations and practice of child soldiering, whether it's Sierra Leone, whether it's the DRC, whether it's in Cambodia as well. There's similar, quasi-similar provisions in Article 91 of the Additional Protocol 1 to the Geneva Conventions as well, under international humanitarian law, otherwise known as the law of armed conflict. And as we see, Article 68 and specifically 75 of the Rome Statute relating to the Trust Fund for Victims and reparations there under. Okay, good. So let's move on and look at the UN Declaration of Basic Principles. The UN Declaration of Basic Principles and Guidelines on the Rights to a Remedy and Reparation for Victims of Gross Violations of International Human Rights Law and serious violations of international humanitarian law. Well, first of all, what are we talking about here? What are gross or serious violations of international human rights law or humanitarian law? What are they to begin with?
Those that are defined in the Geneva Conventions?
Sorry, say again, Carol.
Are they those that are defined in the Geneva Conventions?
Partly, yes. That's partly true. So you're talking about war crimes, grave breaches of international human rights.
That would be ICC as well.
Okay.
There's definitions of the actual acts itself.
Yep. Is there any definition in the UN Declaration of gross human rights violations? You got 15 getting this right. No, there is no definition. Thanks for being brave on that. No, there is no definition, surprisingly, in this UN declaration of what constitutes a gross or serious violation. Before we go on to say, well, why might that be? Why might there be no definition in this foundational document of the UN? Any thoughts, any ideas? Why might there be no definition?
Because when the declaration was made and as compared to contemporary standards, there's always a constant evolution and change and new things coming into what could be a gross violation. Things you didn't think would happen 50 years ago might happen now, and those could be considered as gross violations.
Absolutely, we still haven't worked out all of the ways we can be horrible to each other as human beings. We can't predict which awful things we're going to be doing to each other as societies in 10, 20, 50 years' time. Right.
But it could also just be simply hegemony in international law, where sort of certain definitions are confined or sort of consciously omitted because they have a greater impact in international law, or they reinforce a certain order in the international law, or sort of they keep certain things under the wraps that shouldn't be unveiled. So it could also be a conscious decision that a definition was not put in place, because then that could, like I said before, have a gross box. So I would also just throw it down to hegemony in international law.
That's a fair point. Yeah. Okay, so the definition as essayed by the Office of the High Commissioner for Human Rights, the UN's OHCHR, gross violations of human rights denote types of violations that systematically perpetrated, and that is the key here. It's a systematic perpetration of the rights, the violations I'm going to read out. Affect in quantitative and qualitative terms the most basic rights of human beings. So we're talking here about the right to life, the right to physical and moral integrity, the right to be free from torture, and that encompasses all of the crimes that Cal was alluding to in the Geneva Conventions and the ICC.
I have a question.
Yeah.
So when it talks about systematic perpetration of violence, is it by the state, or could it be, or machinery of the state, or could it be by anyone?
What do we think?
If you say by the state, it kind of restricts the ambit of things, but I'm guessing it wants to do that.
What do we think? Should there be a restriction of perpetration of human rights violations to state entities? Hayden, you're shaking your head, tell me why.
No. I mean, it's the obvious, right? Other organisations that have a stake in human rights violations.
I'm going to ask you a very obvious question, such as?
Militias in all sorts of parts of the world, everywhere.
Okay, so we've got paramilitaries and militias who may not necessarily be allied to the state, they might be fighting for a rebel force or whatever. Who else? Fernando?
Sorry, I said ISIS just like as an example, but
Okay.
also like private entities could commit violations.
Such as?
There are, I don't know, just like private companies.
Bingo, that's what I'm looking for.
Yeah.
So, corporate violations of human rights standards is quite a topical subject. It's something I've written on myself as well. So you can Google my name and something will come up with corporate human rights violations. And it's something that there is a huge pushback against. Why? Well, global capitalism, globalization, some powerful forces there. Multinational corporations have much bigger budgets than many states.
There is an article of principles called Principles of Origin that it's supposed to bind the state and the private corporation in order to guarantee the protection of human rights, and if they were violated, then there should be a remedy to repair.
So this is what Fernando is talking about is the United Nations guiding principles on business and human rights that were drawn up by Professor John Ruggie from Harvard University, and these were very, very similar to this. It was a declaration of guiding principles. Before I say any more on that, the first question I was going to ask, that's relevant to what I've just mentioned, the Ruggie guidelines, on this. So what is the legal basis? What is the legal basis of these, of this UN declaration? The legal effect, should I say? What's the legal effect of the UN declaration?
Recommendatory?
So these are guidelines. These do not create binding legal obligations. And there's the rub, because you see that, okay, fine words, the states must do this, they must not do this. Similarly for the Ruggie guidelines, which are targeted towards states, obligations on states, responsibilities of corporations, but no binding mechanism to hold either states or companies accountable for violations. These are just recommendations. There isn't at the moment a discussion ongoing in the UN to draw up a binding treaty on business and human rights. And you've got two schools of thought. Those who say, unless any human rights mechanism has teeth, unless there are obligations that you've signed up to as states parties, it's a waste of breath to say these are guiding principles or these are recommendatory suggestions. And on the other hand, on the other side of the debate, you say, well, this is the first step to bringing corporations to become accountable for their participation in abuses in the supply chain, etc. I'll leave it to you to decide which side of the debate you fall. But there's a lot of literature on this, and it's quite common in debates on corporate liability as to whether there should be binding treaties.
Do you think like the principles of, I don't know how you pronounce it, Ruggie, is said like could be classified as soft law?
Exactly. So, yeah.
Sorry, in Latin America there's an Inter-American Institute of Human Rights and Social Responsibility, and they're like working in the whole Latin America section to make them kind of binding for the states. So I know it's not like legally binding, but it's just like internationally you would be criticized if you don't comply with it. So.
Yes. So has everyone understood the difference between hard law and soft law? Can anyone give us a, Fernanda, would you like to try a definition, or at least throw some suggestions out there?
Like soft law would be that kind of principles or general international guidelines that provide some protection for human rights but are not binding between states, and that's the main difference between soft law and hard law, which is binding. And then also, if you don't comply with soft law, you will be criticized by the international community, but you won't have any legal effect as with hard law. Okay.
So, big difference between hard and soft law. Thanks for that definition, Fernanda. Hard law, obviously, you signed up to a treaty, you're bound by the terms of that treaty. If you violate it, then there are consequences in law. You could be brought to a particular court relating to that treaty. Soft law, well, if you're violating the basic principles, either on business and human rights or the UN Declaration on Basic Principles of the Right to Remedy, then, well, will there be any definite legal consequences? Not necessarily. Might there be an impact on your legal obligations? Possibly, because why might there be, notwithstanding the fact that these are soft law obligations, or rather soft law rather than obligations, why might there be an impact on your legal liability? You've mentioned, Fernanda, that victims might be able to use this. How might victims be able to use the fact that a state, or in the Ruggie guidelines, a company violates recommendatory guidelines? Ever?
Because the UDHR gives you a right to a remedy, so even though these are just guidelines, there has to be some form of remedy that's ensured, and I think stemming from the fact that that's a use code itself, like there's an obligation on states to fulfill it, and these guidelines just act as a principle to support it.
It's evidence, so it's supporting evidence. So if you're a lawyer acting on behalf of, let's say, Cambodian sugar farmers in the Kokon province, Tate and Lyle are currently going through a hearing in the High Court in London brought by representatives from this community in Cambodia, alleging that security officials of Tame Lyle, with the connivance of the Cambodian government, have been beating, raping, murdering the civilians of particular communities in Cambodia to get them off the land so they can clear it for sugarcane, then you will be looking at any signatories to these basic principles or guiding principles, whether it's on behalf of the state or the corporation. Have they signed up to international best practices? And there may be pressure on states and corporations to sign up to best practices, to demonstrate to their perhaps more ethically aware consumers that they should be doing something about their supply chains. If yes, they've signed up for that, then lawyers acting on behalf of communities such as the one I just mentioned will be using that as evidence to say, and here we have it, a company violating their own standards or what they've signed up for. Okay, let's bring it back to this UN Declaration of Basic Principles. What specific obligations are placed on states by the UN Declaration of Basic Principles? Everybody? Right.
Well, it says obligation to ensure respect for and implement international human rights law and international humanitarian law.
Yes.
And then it goes ahead to give the scope of that obligation.
Yes. So we're talking about here incorporation into their domestic law of all of these international human rights law norms and international humanitarian law norms, adopting effective and appropriate mechanisms through legislature and administrative procedures, making available the information, and that's a key aspect of providing access to a remedy. Unless those whose rights have been violated know A, that their rights have been violated in a legal sense, and B, what to do about it, then the country saying, well, it's all right, we've got this court, it's hidden away around this corner here, and yeah, not many people know about it, but it's still there. It's not going to cut any mustard with the people in the Inter-American Court of Human Rights or the European Court of Human Rights, for example. There has to be also some form of protection, an adequate form of protection under domestic law and for victims in the same way that it's provided for as an international obligation as well. So, absolutely. UN Declaration of Basic Principles. So we've gone through legal status. I mentioned here that it's a victim-oriented perspective. So there's a shift since the declaration was drawn up, a shift towards a more victim-oriented perspective. And we can see that shift not just in international human rights law, we can also see it in international criminal law, as I'm sure you've been talking about in your other modules. We've talked a bit about gross or serious violations, and as Brian has highlighted, the state has obligations under national and international law to adequate, equal, effective, prompt and proportionate redress, and as I said just a few moments ago, access to information. Okay, good. What about the different forms of reparation? So what is reparation? Let's get down to the basics before we go any further. Got the sign-in sheet here. I'm going to call on somebody that's not actually spoken so far. I'm going to be mean. So what have we got? What different forms of reparation? Ding. Ding? Kong Ding?
Counting?
Yeah.
Counting is not me.
No? I'm sorry.
I'm Sue.
Somebody has signed. No? That's strange. Okay, I've got a signature here. They've obviously hidden. Does anybody know who that person is?
I know him.
Okay.
Yeah.
That's very peculiar. So I'm going to cross the person's name off and somebody's name has been signed for. Okay.
But I didn't sign on the
Okay, so who hasn't spoken? Yeah, okay. Let me ask. Name.
No disrespect to the debate, I got my good blind past the sound online.
Okay. Yeah, you're there. Name. What do you think?
It can be restoration in the society,
Yeah.
in situ restoration,
Yeah.
in the situation or the environment where the person belonged before being subjected to any persecution or sufferings. So one form of reparation can be rehabilitation in the same sphere of life where he actually belonged to.
What format would that rehabilitation take? Were you talking? What format?
I mean, the objective of reparation for that person will be to restore him back in the the pre-conflict situation or state of his life. That's what I meant.
How will they do that? How will those that are seeking reparations do that?
Actually, it appears to be practically impossible in some extent, but that can be done, by, aiding financially or, ensuring anything that he used to have before going through.
Good. Okay, so we have
Yeah.
financial compensation
Yeah.
as one of the forms of reparation. So something that is economically accessible, that was damaged, say your house was destroyed, it cost $10,000, you were given $10,000 to rebuild your house.
Liquidated damage, yeah.
Okay. What other forms of reparation?
It says verification of facts or finding the truth about what happened.
Absolutely. So we're talking about the satisfaction of victims by way of truth seeking, historical record creation. What happened to the disappeared, for example, in South America? Those families want to know what happened to them. They can't bring them back. Monetary compensation is often seen as blood money. But they want to know, above all, as we've seen in previous seminars, the truth about what happened. And linked to that, Vivi, you want to say something?
Yeah, I was just going to go to the other forms of reparation.
Okay.
I think the basis of it is restitution, or trying to restore them to the position they were originally at before they went through whatever systemic abuse.
Okay.
Just to be able to restore them or get them near restoration to that state before any harm was created.
Such as, let's give us some examples of that.
Can't think of
Okay.
For example, return to the place that the person was lived before, and return to the rights that he or she was enjoying before the gross violation.
Good. So returning the victims to the place that they've been displaced from, giving them back the rights that they had before. For example, what rights might they have had before?
So human rights, right to election, the democracy right.
Yeah, democratic rights, it's citizenship, I'm thinking.
Or citizenship, yeah.
Also maybe their occupational status, their profession which they might have lost because of this victimization.
Yes.
And also the right to property, which particularly they can lose because of the turmoil.
Yeah. So that's restitution potentially as well. Fernanda, you were going to say something?
Oh yeah, examples of restitution could be, as Kaya was saying, liberty right, enjoyment of human rights, right to an identity, also a family life and citizenship. And this part of being recognized as a citizen is very important in order to guarantee an existence of a democratic government after that. So, because from the reading it says that a victim who's seen as a citizen would help not to be categorizing them just as victims, but actually as people who deserve rights and who are equal than each other, like a process of reconciliation, I would say.
Yes, I think it's important. It's easy for us really who live in democracies to take for granted the rights of citizenship, the right to vote, to participate in the election, democratically elected government. there are many countries in the world where those rights are very much more fragile. And the country that I'm particularly studying at the moment and interested in is Myanmar, and you've heard a lot about the Rohingya Muslim population in the northwest of Myanmar in Rakhine State. And many of the, well, all of the Rohingya Muslim minority in Myanmar, there are several million of them in a population of about 50 million in Myanmar, so not insignificant, don't have citizenship and haven't had citizenship for the last 3 generations. And this lack of citizenship prohibits them becoming lawyers, participating in government, and protecting the rights of their community that we see on the screens of our televisions today. So let's not underestimate the rights of democratic participation. So let's look at this very briefly. Restitution, we've talked about compensation in monetary terms, rehabilitation, we've not mentioned specifically, but we're talking about perhaps psychological support, psychological care, medical care for those who were bodily injured as well. Satisfaction, we're talking about truth, the search for the history of a country, effectively. And one thing that we've not mentioned so far is guarantees of non-repetition. So very important aspect to reparations is that the victims will want the state, who by and large are the ones that are mostly responsible for perpetrating the atrocities, they want the state to guarantee that these will not happen again.
I have a question. Is there any negative aspect of providing reparation to the victims? So, for example, in the present context, the right to forget anything that is just, depriving someone to lead a normal course of life is being discussed in international plane. So, if anybody wants to forget the scary experience that they had been during the persecution or victimization in the time of conflict, so can there be any form of reparation that will help them to forget? I mean, in contrast to setting up certain memorials and monuments, they want to forget that. So, is it possible? I mean, will it be termed as a form of reparation? Is it?
That is a really interesting question, and I'm going to throw that open to the floor. What do we think? Should there be a right to forget? If culturally it is not being done in your community to keep remembering the past, but to block it out and move forward, should we impose this right to remember where people want to forget? What do you think? Cal?
There's also the other side of it. I was watching something recently about the Nazis, Germany, the Nazis that remained in the German state post-World War II, and they were arguing for the right to be forgotten, rather than the right to forget and to move on.
Yeah.
I think that other people also should have the right to know what happened, not just the communities that were directly involved.
I think it depends on the situation, because for example, I have an example from my family that during the Second World War, my grandfather, who was still a kid, was evicted by Russians, not by Germans, because he was on the other side of the Poland. He was evicted with his entire family, or like the Russians came to the house, were like, you have 5 minutes to pack your stuff and get out. And they just took the house, they started like drinking there and everything. So they are like left in the middle of the country. So they moved to France and during the Second World War, and they stayed there and they never came back to Poland. They didn't want to. They wanted to forget. It was like nothing never happened. And I think they had the right to do this. Someone proposed them, oh, you can come back to your house and everything. They said, no, we don't want to. We want to stay here. So I think it depends on the personal situation, because many people came back.
Sure. Ruth, you want to say something?
Yeah, I think I agree. I think the main purpose of transitional justice, first and foremost, is to help the victims, is to help the first-hand victims. And if they don't want to remember it, if they don't want to keep talking about everything and bring everything up, if they want to move on, then that should be the first step, and then they should be able to.
I think there's another angle from which the right to forget can be viewed, which is from the perspective of the perpetrator. And it's not something that's guaranteed to states or countries that, indulged in whatever activities. Do you give them the right to forget without even holding them as much as morally liable for their actions? While I agree with them from the point of view of the victims that the right to forget is something that should exist for victims, that right to choice basically, whether they want to remember or whether they want to forget, which I think comes through the right of choice indirectly. But I think it shouldn't be as much a choice question for the perpetrator. They should not be allowed to forget the kind of violence and crimes that have been perpetrated onto whatever kind of society.
Yeah, it's a really interesting debate, this, and we've talked again about the importance of context, and it depends on the situation. Does the community speak as one? Should we forget those people that might have a different instinct or impulse? You can't obviously take a transitional justice mechanism off the shelf and then transplant it hundreds of miles away to somewhere else. But to be discussed in our own time on this. Okay. Good discussion. Let's move on to the challenges of reparations. So let's think of some of the challenges and discuss this a little bit. What might be the problem with reparations?
The basic challenge should be the political will of the current regime to provide reparation, while they will be predominantly showing that they might have scarcity of resource to for the victims to be remedied, and that can be a political decision that can potentially harm the process of reparation.
So there has to be, like every other transitional justice mechanism, there has to be political will. Absolutely, good, thank you. What other challenges might there be?
Saying that how can you put, if you're giving monetary reparations, how can you put a price on something that people have gone through? There's never really going to be able to pay. It can be seen as a payoff.
So there are sensitivity issues as to how these reparations are communicated. Are they properly explained to the community affected most by the violence? If not, you risk very much being looked at buying as blood money the silence of the victims. Yeah, any other thoughts?
The completeness of reparation, this is to say, like, is the program being able to actually reach every victim, or is it not? And also the complexity, which kind of benefits it's going to provide, just like material or symbolic, and to whom, and what are going to be the categories to actually provide these benefits.
Good, so this concept of completeness in reparations is a key term, a key idea. How do you go about achieving completeness? How do you go about affecting or touching all of the victims that were affected by this? Kai's shaking your head.
No, you can't. It's
You
not
can't.
possible. Sometimes you can't reach, because, for example, let's say half of the family died in the
Sure.
war.
Let me put it another way. How do you attempt to ensure that those who want to be compensated or have their situation
Maybe
dealt
you
with?
can make some kind of programs like that people can kind of come to like one office and say, my rights got violated and the restitution of reparation. I don't know.
So there needs to be programmatic and systematic intervention here.
Yeah.
What characterises a good reparations programme, do we think? What sort of things, if you were running today a reparations programme for a place,
I
what
would
would you...
try to get, because there are definitely some kind of documents during the conflict, let's say, I would try to like search, like history-wise, like search for every person that was violated. But I know it's not possible to reach everyone that way. That's why I would be like kind of advertising, like whoever got hurt, you can come and like we can discuss this.
Advertising.
Yeah.
Information. So
Yeah,
information is
information.
absolutely key. As we were saying before, you want to disseminate this widely. Now you were saying?
But there can be another mechanism to attract the potential people to come within the mischief of reparation by way of opening a sort of public hearing, and that's what she said, like, advertising and let the people know that this program is going to be launched soon, and also examining the national and international news that was published or telecasted or broadcasted in that particular time of conflict. So that can also have some insight from where we can take something, we can get some information.
So, good points. We need information. We also need participation of the victims. It's no good if they're not in them. Sorry, sorry.
We're from neighbouring
Sorry.
places, basically the same
Yeah,
thing.
okay, got you.
So the OHCHRC paper lists 5 factors that will sort of guarantee, we don't guarantee it, but sort of create a vision of completeness, which is, like Chris mentioned, information, participation, outreach, access, and evidentiary threshold.
Good. I want to just pick up on one of those, the evidentiary threshold. So what we're talking about here is the standard to which a purported victim needs to reach before being able to persuade the authorities that he or she is entitled to reparation. This is something that's been bedeviling a lot of reparations organisations or reparations schemes across the world, and causes a great deal of unhappiness and distress. Why might this be? And what are the particular
one of the forms of abuse could be clean torture, which means that you take one of the victims, you torture them in certain ways that aren't evidentially physically. So when that person who's being tortured, say for example the forced standing on cold concrete floors, can be seriously debilitating, but it's preventable. Or psychological torture. You then go to the Truth Commission and say, look, I've been tortured for 2 years in Guantanamo or something like that, but you know, I'm still going to toenails. You know, so well, there's the evidence. You say, well, look, you can't prove it. If there's no paperwork, you can't prove it because you know you haven't got your legs broken or something.
Yeah.
Then that's below the threshold.
You've mentioned 2 things there that I want to pick up on. So the re-traumatisation, effectively, of torture victims or victims of a human rights atrocity in failing to satisfy the authorities that they're within the evidential threshold is one angle. But also the lack of documentation as we'll see in Guatemala, there are real problems in proving title to land, and unless you have that proof of title, that this is the land that I held before the military took it from me, how can you prove that you're entitled to an equivalent amount of compensation at the end of the reparations process? So it has to be dealt with very sensitively, very carefully. How does a society or reparations program properly assess the evidentiary threshold? On the other side of the argument, of course, is if you make it too easy, or if you make it, well, anyone that signs their name here can join the reparations program, then you'll have bogus reparations claims.
I think a lot of people learn from Nuremberg not to keep extensive records.
Some did, some didn't. The Khmer Rouge in the Cambodia genocide kept pretty extensive records, but yeah. Okay, so challenge is completeness. Which violations are we looking at? Which violations qualify? How serious does the harm have to be before you're entitled to reparations? What type of benefits are you going to be given? Are you going to be given a payout in cold hard cash, or is it going to be a memorial built to the community? And what are the aims, what are the goals of the reparations? Are they just to compensate individuals? Are they, as we looked at a couple of slides ago, to do with reintegration of child soldiers into the community, or reconciliation? How are reparations financed as well? And again, another key challenge that governments have to face. Are they financed through a specific ring-fenced trust fund, which may or may not be topped up, or are they a specific line in the budget, for example?
Just a question. When it comes to financing reparations, what is the amount that is due? What it was valued at when the atrocity happened, or what it is valued at now, and how it is compared?
What do you think the answer is to that?
It's just a random amount, the basic minimum that can be given.
Does anyone have any thoughts on that? How should say you've decided as the chairperson of the reparations committee that you're going to be giving cash to victims that can prove they have had a family member killed. How much are you going to charge them and say that they should be owed? Right?
It will certainly depend on the paying capability of the state, and it should also be proportional. But in doing in doing it proportional, we cannot cross the threshold of the state capacity. So, and we also try to evaluate that what should be adequate for them, adequate and effective reparation for them in that current context. Though life cannot be monetarily, remedied. So, but the current need of that specific family, we will try to assess that in terms of reality, and we will try to strike a balance between the capacity of state to pay and the needs they have currently.
Excellent, that's exactly what we're looking for here. What is the capacity that the state has to be able to contribute to the reparation? Because in some ways it can only ever be symbolic. The state's coffers are not bottomless, they're not limitless. There will be a finite amount of money available to the state to pay out to victims. What do? You estimate how many victims there might be and how much money you might have in the budget, and you divide one number by the other and see whether you get to a round number or what. The state can't promise more than it can give, or shouldn't promise more than it can give. And as we've already talked about, what links might there be to other transitional justice mechanisms? Is the receipt of reparations conditional or linked to a truth commission or to prosecutions or to some forms of institutional reform, for example, which might be important? One point on that is that there may be greater legitimacy of reparations if they are linked to other transitional justice mechanisms. If they're just, here's your $5,000, now go away and don't talk to me again about your problems, in contrast to, yes, you're going to have $3,000, but we're going to ensure that there's a memorial, we're going to ensure that there's psychological support in the community. It's not just about the hard cash. An issue that we've not mentioned is gender sensitivity. Why might this be a particular challenge for reparations programs?
Culturally independent. Different cultures treat gender differently.
Okay. So
some may be less sensitive to women's rights.
Okay. How might that be reflected in any reparations program? What might be the problems in reparations programs?
It might not even be recognised. A woman, say in an extreme society, a woman might not even have the chance to be recognised to go and present herself to court. Saudi Arabia comes to mind where women are pretty much out the water altogether.
Okay, yeah. Deborah?
There are certain crimes which are specific only to women, which are imparted only on women. And while you're looking at crimes against humanity in general, it's a general classification of what amount of reparations is paid to each person without actually considering the harms suffered by a gender in particular.
Yes, exactly. Just keep yourself.
I think it's also important to consider the fact that in a lot of societies it's predominantly the male of the family who works or brings in income mostly to families, so I think that should also be considered on both sides, because it's predominantly men who disappear as well. So you should look at the fact that if a male has been removed or killed from within a family, in fact will impact the livelihood of the family if there are any men who can replace that male, if that makes sense, so they can go out and work, or so you consider loss of wages, from the loss of a person within reparations.
Good, yes. Also thinking about the disproportionate impacts that some of the violations have on women in the community that may or may not be mirrored or reflected in the reparations that are paid. And also thinking about the way reparations are designed. So unless there are women in the committee in which reparations are determined, the voices of women, the specific needs of women may not be adequately reflected, which will have an impact on the exact reparations that are given out. Okay, we're running a little behind time because of all of the excellent debate. I'm not criticising anyone for that, I think that's great. So let's have a little break now. We'll come back to finish off the introduction, and then we'll go straight to the presentation. So it's now, I'll make it 3 minutes past 2, come back at 10 past. Yeah, thank you.
Destroying that fund or that money, and ultimately the society as a whole has less chance to be benefited. So to make the society ameliorated and to advance the society as a whole, I think we should better go for the collective reparations.
Okay, good. 2 quick points, so Jessica and then Dante.
Yeah, one thing that I don't know if anybody wants to expand on this, but one thing that I find quite interesting is that often in developing countries there's a favour towards collective reparations.
Yes.
Especially in the forms of development within society, so building hospitals, schools, etc. And governments often say that that's their form of reparations, and often within those sorts of societies, individuals find it feel that they don't need a school or a hospital or whatever. They want individualised reparations because, you know, if you can't feed families, why would you send them to school, or, you know, that sort of thing. So I think it's quite interesting that a lot of developing countries do go for this sort of mechanism and say, well, we're restructuring and reorganising like basic human rights or basic human needs, when in reality, or at least it can be perceived by the individual that that's not what they want. So
yes.
I find that quite interesting.
Interesting, yeah. Darko, do you want a quick point?
The legislative review of individual reparations fails to recognise that human rights violation is an effect of the entire society as opposed to just one person effect because of deeply affecting them. Collective reparation would be much suited to address the point that everybody's benefited, not just the individual.
Yeah, good points. Well, very quickly, in the next just couple of minutes, we'll whiz over the next slide. The difference between reparations and development, and then we'll come on to Guatemala. So, what is the major difference between reparations, whether it's individual or collective, and development? Indra, I've not heard from you this afternoon. So, what would you say is the main difference between reparations and development?
I'm not sure, but according to reading, reparations is a process. So if it depends how successful were the reparation process and how it was like if the victims received everything they were about to receive or not. So I think it's the link, like if everything was done right from the part of the state, like it can lead to development, or I don't know if that makes sense.
So you say reparations could lead to development, but not necessarily the other way around? Or
yeah, also the other way around, I guess.
Is there a fundamental aspect of reparations that is qualitatively different to development? Is there something that reparations are trying to do that development is not, for example?
Not sure.
Okay, let's see if anyone can help me out.
I think reparations have a very large moral obligation
Exactly.
towards them, whereas development is based solely on like the social, political and economic climate of the country.
Yeah.
So whilst reparations do have a legal aspect to them, they are fundamentally based in the moral obligation of a state to its citizens.
So it's a moral obligation to repair harm on the part of the state to the victims that suffered in the human rights abuses. Debbie, you wanted to come in?
Yeah, reparations are corrective measures, remedying a wrong that has been done, whereas development is, let's say, equality, or ensuring that certain things are available to all citizens across.
Yes.
And while you can look at things like positive discrimination and stuff, within both, I think it falls more under being corrective because of whatever's happened in the past.
Good. So we're talking about corrective justice rather than development. Cal?
I'm just thinking, there's a great example of how the two are linked in Liverpool. In 1981 there was riots in Liverpool and the Margaret Thatcher government, she set up a Minister for Merseyside, Heseltine, who then created a space of development, as part of reparations for the riots, created a space of development called the Merseyside Garden Festival. Now, that's just the top of our road actually, but what happened with that is it created that little tiny trinket that was thrown in the Merseyside area, and it's sort of pretty to look at. Actually started the regeneration of Liverpool 30 years later. It's now a massive city. In 81 it was pretty much a Labour run shithole, you know. But in that development, that little tourist thing brought millions of people, even brought the Queen here, brought millions of people and changed the perspective, the perception that people had of Liverpool. And from then, it regained its capitalist origins. Liverpool's a capitalist city. It regained its capitalist momentum and started to build up. So that's where the reparations and development is linked, and it's just there.
That was very much more development than reparations. It wasn't specifically repairing.
I think originally it was about pretty much give something to this cow, so shut them up, say, here's your little trinket, look at these nice flowers. But it then turned into a totem for development.
Okay. How about the idea of what tensions there might be between reparations and development? What might be the major tensions here? Who's paying? Brian?
I just was thinking of the tension that in certain contexts, certain governments have tried to claim that development processes that were going on were already reparation programs. For example, in Peru, where there was a protest from the victims, but the government had initially, where they were supposed to pay reparations, they tried and claim that the development activities that were going on were that form of reparation. So that could be a possible tension where sort of people responsible for paying reparations use development initiatives as a way to sort of evade and get out of the reparations program.
To avoid the moral responsibilities of paying respect to what happened in the past. Exactly. Okay, I think we're probably going to have to whiz through the rest of this to give the group that's presenting on Guatemala the time to present. So what should the difference be? We're looking at a moral component of reparations rather than the moral component for this limited. Well, there's a legal right to development, but there's not the moral imperative that exists to repair a harm that reparations deal with. Tensions, well, there's a finite amount of money that a state might have. Should it give the money to specific defined victims or the wider society through development? What synergies might there be? Well, Cal's example, you might think that there are development possibilities that come out of a situation from which there has been reparations, and they're both processes involving, as I write here, civic trust and civil society. We don't quite have time to go through Pablo Kalmanovitz's discussion of corrective justice and social justice. I'll leave you to look at that in your own time. Let's move swiftly on to Guatemala. Let's go east. Okay, so which is the group coming up? So Viva and others. And Cal, and who else is coming up? So we're now on 2:30, so 15 minutes to 2:45. Will you manage that? Yeah, great, thank you. Okay. Okay, take it away.
So we're doing presentation of the reparations in Guatemala. So to start, Ellen will go over a brief history of conflict within Guatemala. I'll then go on to speak about the ICTJ and the legal basis for reparations, which we've kind of spoken about. Viva will then go on to discuss the moral implications of reparations, and Cal will finish off by talking about the reparations program within Guatemala.
Okay, so Guatemala gained independence after being under Spanish control. The quality of the civilians' life didn't improve because of the dictators that took control. It eventually led to the Guatemalan Civil War. In 1951, they got a democratically peaceful leader called Jacobo Arbenz. And at the time, people thought he was a good president because he was elected freely and appeared to be making positive changes for the Guatemalan people. The US took a disliking to him because he was taking steps to nationalise the plantations of the United Fruit Company. And so the US CIA trained the back coup commanded by Colonel Carlos Castillo-Armas against the democratically elected president in order to stop the communist threat. Following the coup, Castillo was declared president in 1954 and set about reversing land reforms that benefited poor farmers. He also removed voting rights for illiterate Guatemalans. Although his reign was short-lived as he was assassinated in 1957, Guatemalan politics degenerated into a series of coups and counterparts, coupled with brutal repressions of the country's people, and that was the start of the 36 years civil war when guerrilla groups started battling the government, military forces in an attempt to overthrow democracy. This continued throughout the 60s and 70s. So the long conflict was marked by introductions of violence, including mutilations and public dumping of bodies. In 1970, military-backed Carlos Arana was elected president, and he immediately placed the country under a state of siege, giving the military more control over the civilians. For the next decade, a series of military-dominated governments escalated violence against guerrilla groups and indigenous communities. The war progressed into the urban areas of Guatemala after being in the rural areas for over 30 years. Military and civilian buildings were then attacked. In response to the MONT government is now in place, but there was local civilian defence plan, troubles along the military, country and rural indigenous regions, through which he was able to reclaim most guerrilla territory. This crackdown against the United Coalition marks one of the most violent periods of the Civil War. From this came a drafting of the new constitution. In 1993, then President George Serrano illegally dissolved the Congress, and the Supreme Court restricted civil rights but was later forced to resign. In 1944, and the President Ramiro de Leon Carpio, the former human rights ombudsman, peace talks between the government and the rebels of the Guatemalan Revolution, national unity began, and agreements were signed on several issues, including human rights. In 1996, a new president, Alvaro Arthur, was chosen in a runoff election. Under Arthur, peace negotiations were finalized. Today, Guatemala is led by President Alvaro Calor and united with national unity for hope. Almost 15 years after the end of the Civil War, violence and intimidation continue to be a major problem in political and civilian life. Organised crime groups operate with relative impunity, an issue that appears to be a likely factor prominently in the country's next presidential election later this year.
So the ICTJ is the International Centre for Transitional Justice, and it's a non-profit organisation which specialises in transitional justice. It works to help societies who are in transition address legacies of massive human rights violations and build civic trust in state institutions as protectors of human rights. They do this by assisting institutions and civil society groups in considering measures that will be that will help them to provide truth, accountability, and redress any past abuses. The ICTJ partnered with the Open Society Justice Initiative to create a website that was devoted to covering the trial of Rios Montt. And they also partnered with Impunity Watch to produce a report on the International Commission Against Impunity in Guatemala, which was a hybrid mechanism by the UN and the Guatemalan government to strengthen prosecution in criminal groups. Their earlier work included advising the government on the best practices of reparation policies, facilitating an exchange between a representative of Guatemala's Reparations Commission with Peruvian counterparts, training attorneys and prosecutors and judges to work on human rights cases, and providing long-term consulting work to the Attorney General's office. So what are reparations? Well, reparations in principle are, as a principle of law, has existed for centuries, as we've discussed, and it refers to the obligation of wrongdoing of a wrongdoing party to redress the damage caused to the injured party. So under international law, as we said in the, how do you say it, Kaya? Factory case, reparations must, as far as possible, wipe out all consequences of the illegal act and re-establish the situation which would, in all probability, have existed prior to the act being committed. So at the most basic level, reparations seek to repair damage or harm that was unjustly inflicted on an individual, group, or state. So the legal basis for reparations, according to Renee Jeffrey in her article Beyond Repair, which focuses primarily on the Khmer Rouge trial, she states that a legal basis for reparations could rest in the concept of unjust enrichment, which is an idea traditionally associated with relationships between individuals. Unjust enrichment involves circumstances that give rise to the obligation of restitution, that is, receiving and retention of property, money, or benefits which in justice and equity belong to another. So that basically means that you've taken something unjustly from me, so I'm going to give it back to you, or at least give something back to you to repay for that. Furthermore, Sean and Baxter states in their article International Responsibilities of States for Injuries that reparations in their ideal extreme form a restitution designed to re-establish the situation prior to a wrongful act or omission. Furthermore, Article 31 of the International Law Commission's draft articles on the responsibility of states for internationally wrongful acts and the United Nations Basic Principles and Guidelines on the rights to a remedy and reparation for victims of gross violations of international human rights law makes clear that in cases where the permanent nature of a crime has been committed and has rendered restitution impossible, for example, where victims are murdered or severely tortured, reparations ought to take the form of compensation, rehabilitation, guarantees of non-repetition, which I don't know if we discussed, but that was quite key, and satisfaction that something like this won't happen again.
So I'm going to talk about what moral reparations are. Is there an aspect of morality that needs to be included in reparations? A, is there a moral duty on states or perpetrators to acknowledge in terms of reparations or just in terms of an apology what has been done? And also, is there a moral basis on which, like, there are two things that I'm questioning. One, is there a moral basis on which you can seek reparations? And two, is there a moral obligation that's created during reparations? The extraordinary chambers for ECCC in Cambodia basically say, while they were talking about the case one, they said that civil parties can seek moral and collective reparation. Such reparation can only be awarded if an accused is convicted. And what they're looking to do here is club morality with collective justice measures and say that it affects not just one individual but a large society or community, and that what can be derived from this is that there is a moral obligation on states to acknowledge that there has been something wrong that has gone on. Now, the ECCC goes on to talk about, under the ECCC, who pays who bears the cost of reparations. Now, when you look at it in general, when you're looking at it from a morality and like philosophical perspective, there's no right or wrong. So is there a duty on states to come together to provide this amount for reparation, or is it the perpetrators themselves that have the responsibility and owe the responsibility to a state? So there's been little research that's been conducted on the experience and opinions of survivors regarding issues such as reparation, justice, reconciliation, and truth in dealing with the aftermath of atrocities. And less still has been said on the way in which victims' identities impact on these views or are considered in the design of programs aimed at redressal for past violations. Now, talking about that a little bit more, if you looked at the impact of a civil war or colonization or slavery that has happened for so long in a lot of nations that have been oppressed, you can see that there's been a complete change in the societal fabric or societal structure because of this. And there's marginalization of communities which cannot be undone. It can be addressed, seek to address through positive discrimination, but you can't take away that there's been creation of a different fabric that wouldn't have existed if not for these atrocities. So what is the moral obligation? What is the moral obligation that's owed? Apart from talking about material reparations to address physical damages, does an apology count as reparations? Is the owning up of guilt amount for reparation? Does it always have to be in terms of physical damages or repaying a society for loss? How do you, kind of add a moral value to anything that's been done? Yeah, so like I said, there have been a couple of instances where you go, and again while asking the question of how far back do you go while looking at this argument, in 2009 the US Senate passed an act where the Congress apologized to African Americans for what they had done. Canada at some point during Justin Trudeau took responsibility for a ship that was sunk with Indian refugees. So now this is the question that we've tried to address, that does transitional justice seek to address the morality aspect of oppression through reparation? We have a small video which talks about it, which is just 2 minutes long, if you can play it.
I have problems with playing videos this morning, but just try it and see if it works. No, that's the error I was getting as well. It might not be possible, sorry.
Yeah, so wait, just see if there's cool.
Only has one row that's
Don't worry, that's fine.
Yeah, thanks.
Real quick. The violations that reparations benefits are meant to address are frequently of the sort that is, strictly speaking, irreparable. Nothing will restore a victim to the status quo ante after years of torture and illegal detention, or after the loss of a parent, a sibling, a spouse, or a child. No amount of money and no combination of benefits can erase such experiences or some of their consequences. However, understanding the inherent limitations of the programs in question, effects by the established and run, and the benefits they distribute. The warped development patterns facing the government that design and implement reparations programs are slow to change. One of the biggest hurdles to the programs in both Peru and Guatemala, for example, has been the need to channel a transitional justice strategy through existing state structures that are ill-suited for the purpose, to the extent that they exist at all. In addition to a lack of resources and often preparation, government and ministries tend to operate in separate silos without much communication with other ministries, and often in mistrustful, competitive relations with them, making it even more difficult to create integrated programs. This has led to long delays, to frustrations for victims in dealing with the slow and often unfeeling bureaucracy, and to problems operationalising the delivery of money and services. The normal problems of a weak state unable to deliver benefits or services effectively are exacerbated when infrastructure is being neglected or destroyed during armed conflict or military build-up, and much needed professionals are being killed or exiled or emigrated. In Guatemala, where inter-American court ordered collective reparations, for example, in the Planty Sanchez case, have included mental health services, the state response by sending therapists with no experience dealing with victims of massive crimes into rural areas where they were completely ineffectual. Moreover, local people complained that the doctors who were sent to staff the local health clinic as part of reparations to the affected community were just as racist and dismissive of their complaints as the doctors they had previously encountered. So much so that many of the victims no longer visited the clinic. One possible solution to explore, or we could say exploit, is to bring foreign workers in from developed states who can oversee the fair distribution of services and who can then bill extortionate fees with crippling interest rates, such as what the World Bank and the IMF do, who are notorious for driving whole regions to the verge of bankruptcy. Or maybe we should just be wary of this form of disaster capitalism that hide behind NGOs, or when practitioners of transitional justice they say they are there solely to repair states. It's interesting that the ICTJ lives on donations from certain states who are politically aligned with them, but it's only Norway, Denmark and Switzerland who are specifically asked that their donations are made public. There's NGOs like, you could argue, like Soros, who, with backers like Halliburton, we saw in Iraq, who go into states who are ruined and use this, exploit this area for capital gain. And the problem with the victims are getting nothing.
Okay, thank you very much, gentlemen and ladies. Okay, some high-level philosophical debate and political discussion there. Thank you very much. Let's just remind ourselves very briefly in the 5 minutes that's remaining some of the features of the Guatemalan conflict and the aspects that the reparations program tried to redress. So, Guatemala was plunged into civil war by a typical Cold War process of corporate interests and capitalist interests being challenged by more left-wing interests. The government was propped up and then a civil war ignited by American support for the corporatist section.
And predates the Cold War.
Predates
the Cold War.
Yeah, it does, but then it overlaps the Cold War because it's 36 years.
Yeah, but I mean, that kind of thing would be happening since the 10th century, pretty much.
Yeah.
Time before the Cold War.
That's a fair point. The way as I saw it developing in the 70s and 80s was the oppositional capitalists versus communists, and the leftist guerrillas versus the Reagan-backed government.
That's it, right?
Yeah. But the idea being that the state of Guatemala, let me just get the right slide up here. The state of Guatemala ended up being very corporate driven. Guatemala is a country rich in natural resources, and there were hydroelectric programs that were created, the damming of rivers, the destruction of communities. It was also a very indigenous rich country. The Mayan civilization goes back thousands of years, and there's an awful lot of racism and structural injustice built into the country. And so, just some quick statistics. There were about 250,000 people killed in the Guatemalan conflict between 1960 and 1996. 93% of all human rights violations were committed by government forces rather than guerrillas. There were over 500,000 forcibly displaced, many tens of thousands of rapes, and tortures and disappearances. And so we have racial intolerance, we have structural injustice, we have an influence of corporate powers, we have state-sponsored terror, and the fact that it went on for 36 years caused a great deal of difficulty for the two truth commissions that eventually came about after the Civil War ended. And this was all attempted to be rectified by the National Reparations Programme, the PNR. And in the end, there were various figures put on what reparations were going to be given to the population. So these were reduced to $2,700 US for rape and torture victims, $3,200 for families of people who were executed or who were forcibly disappeared, $5,000 US for families who had lost more than one family member. Now, if you repeat the statistics like that out loud, it sounds very stark. That ended up being, at least for many years, until very recently, the only form of reparations that were paid by the Guatemalan state to the many hundreds of thousands of victims. And although there was the very ambitious National Reparations Programme to include symbolic, collective, cultural, memorial reparations, for the vast majority of the last 20 years or so, only those individual payments were paid. And reference has already been made to the Plan de Sanchez massacre that Cal mentioned, which took place in 1982. There were 250 Mayan villages that were massacred by the state forces. And that has recently been reprised by the Chishoy Dam, and we were going to look at this. We were going to look at a short video on this, but there was not the technology to play it for today. I apologise for that. I'd encourage you to watch that video, and then follow it up by a Google Scholar search of the Chishoy Dam reparations program that were only really starting to be paid out in 2015, and this was 30 years after the original massacres whereby 450 Mayan Indians were killed by the Chishoy Dam Company's security forces who were driving the Mayans off the land in order to get at the land to dam it. And I said only a couple of years ago, 2015, these were reparations that were finally paid by the state. They were also finally supported by the World Bank and the Inter-American Bank, because there was a direct link between the financing of the dam and these banks. And in an Inter-American Court of Human Rights decision, there was legal authority to show that it was also international corporations that were involved in this as well. So it's a very interesting concept of what reparations have meant in practice, but Guatemala is a particularly egregious example of human rights abuses targeting indigenous populations with a very complex and long-lived process, civil war process. I think we've probably run out of time, but if anyone's got any final comments or thoughts on reparations or on comments?
I just had a quick question. I think it wasn't that long ago that there was talk of Efren Rios Montt, I think, of trying him.
Yeah.
But legally speaking, he couldn't because he was still in office and he had certain protections because he was still in office. Was he ever tried?
Yes. Rios Montt was tried. He was convicted in 2014 for genocide, crimes against humanity and other crimes. But that conviction was overturned by the Constitutional Court in Guatemala because of procedural irregularities. The retrial was started in 2015, and it was halted because there was a challenge to the legality of that court. His current status is he's alive, he's 90 91-92. The charges against him have not been dismissed, but there's been a formal ruling by the Constitutional Court to say that if he is ever convicted and sentenced, he can never receive any punishment because he is suffering from dementia. So it's a very unsatisfactory conclusion to General Rios-Montt.
A very specific question as to taking reference from what Viva presented about the moral obligation of the state to in terms of reparation. So can we make other state in any way accountable to say sorry for the atrocities they committed in another state in a given point of time? I'm just referring about the historical struggle of liberation of my country, Bangladesh. And how can we proceed to, I mean, Pakistan saying sorry about what they did and to make them bound to make liberation?
Well, what do you think?
I think, I mean, there is a growing need nowadays because these are already evident in international play that the atrocities they made were one of the most heinous examples in the history of the world. So, I mean, they should be accountable and they should say sorry also because, you know, sometimes we hear that they are not at all sorry and they don't think that they have done anything.
I think this is too big a discussion to leave to the final dying seconds of a transitional justice class, but I'd encourage you, if any of you are interested in it, speak to them, look at the International Court of Justice's remit. Not next week, the next seminar, I wrongly said was next week. The next seminar is the 1st of May. Okay, so Padre's seminar is the 1st of May, so there's a reading week next week for transitional justice. The next seminar, 1st of May, don't turn up here next week, and it'll be on traditional justice.
1st of May or 1st of April?